This honorable court is now in session.
Thank you, Ms. Dempsey, and on behalf of Judges Bennett and McClarty, we welcome counsel to this oral argument that we are live streaming so that we may fulfill our obligation to maintain open courts. Each of you has 15 minutes for your argument, and the appellant has reserved some time for rebuttal. There being no announcements, I'm asking Ms. Dempsey to call the case.
David Liles et al. Versus Michael Young et al.
All right, counsel, you have the floor.
Thank you, Your Honor. If it pleases the court, I'm Roger Manus, and I am the lawyer representing Mike Young, the defendant Mike Young, in this partnership dissolution case. I've been before this court many times in the past, and my late best friend Jerry Lee used to accuse me of having a monstrous ego. Well, unfortunately, despite that, in this case, I think I can fairly say that and this is no casting no dispersion on my longtime colleague, Mr. Huff. This is probably the only argument I've ever made where I can truthfully say I don't understand the arguments made by the other side in it. So I'm going to try to simplify it from my perspective and give the court my perspective of it as quickly as I can, and then maybe follow up and rebuttal and try to answer any questions. The underlying numbers in this case, in terms of the contributions of the parties, are not in dispute. They're concrete. Everybody agrees what they are. Everybody agrees what the front end capital contributions were, and everybody agrees with the calculations of Mr. Liles' service fee at about $118,000 spread out over that time. Nor was there any dispute about how to go about calculating Mr. Liles' ownership interest in the partnership. Mr. Liles asserted in a verified complaint in this case that this attachment A, what we refer to as attachment A, prepared by the accountant, was the proper way of determining his ownership interest. He had, from year to year, inserted the numbers into that attachment and worked down the ownership interest to the point where he thought he had about 19% at the end of 2017. Problem was, he didn't realize, and we didn't initially realize, that he had simply failed to account for additional capital contributions made by my client to the tune of about $238,000 during the life of the partnership. When confronted with that in his deposition, an amended complaint got filed sometime after that. Also verified, also contained the same exact assertion that this particular attachment was the right way to go in calculating his ownership percentage. But there was some other additional information alleged about some other things that needed to be addressed. But I'd like to point out to the court that the issues framed by the pleadings in this case relate only to the ownership interest of Mr. Liles and dissolution. That's in both complaints. So those are the only issues. All this other stuff about profits and capital accounts and all that are outside the scope of the pleadings in this case. What this case started out to be about, and as far as the pleadings are concerned, is still about, are the ownership interest of Mr. Liles and the whether the partnership should be dissolved, which everybody agrees with. So there's really only one issue, and that's the ownership interest. Now we have, in a very simple fashion, set forth why we think Mr. Bradford's calculations are nonsense, and that there are two simple math tests that we applied, and there was really no effort made in the brief of appellee to specifically address those math, those sanity checks, if you will, or reality checks in terms of the capital in this partnership. There was some reference to the fact that we were challenging Bradford's mathematical calculations, which we weren't. We were just saying that he was inserting things into the case that didn't make any sense. He was conflating issues. But in terms of addressing the problem of of these two mathematical computations that proof checked, if you will, his theory, no effort was made to address that whatsoever. And so that stands unrebutted at this point. So I guess one thing that was frustrating to me about the court's ruling in this matter and the arguments that were made in the brief of appellee are that everybody agrees in this case that this is an unambiguous agreement. Mr. Bradford got perilously close, I would say, to telling the trial court how to interpret a written contract that everybody agreed was unambiguous. In other words, he came perilously close to invading the province of the court. But the one thing that I think everybody agrees in this case, and including the very end, the conclusion of the brief of appellee, is that the agreement could not be more unambiguous in respect to the fact that Liles is not to receive, under any circumstances, any cash remuneration for his work that he does in connection with his partnership, other than to the extent that his partnership ownership percentage gets increased by virtue of that service fee. And at the time of dissolution or sale of the assets, he would be compensated based on a percentage of the value of the assets on it, the net value of the assets on it. So all of this stuff about the capital account and the profits seems to me to be an effort to divert the court's attention away from, and the trial court's attention away from the fact that we've joked in the past about my elephant metaphors that I've used, but the elephant in the room in this case is that Mr. Liles twice has sworn to the trial court, and which stands unmodified and unamended at this point, that the way to go in calculating his ownership interest in this matter is set forth in attachment A. It was never withdrawn or amended, and it was only an effort made to get Mr. Bradford before the court with some theory that, frankly, I cannot understand until after it became apparent, when it became apparent to Mr. Liles that he had simply left out a capital contribution entry that he had made in the books, in the QuickBooks of the company. He was the bookkeeper for the company, chief financial officer. He made the entries in the QuickBooks, and as he was extending that attachment A from year to year, which was really done for tax purposes primarily from year to year, he just simply did not include those capital contributions, which would bring down his ownership percentage from about 19% to a little bit over 14%.
Mr. Manus, wasn't that brought to the attention of the trial court?
It was. Several times.
And the trial court considered it. So why was that error?
Why was what error?
Well, if the trial court considered the capital contributions, how did the trial court err?
Well, the trial court erred because the trial court concluded that Mr. Liles had a 20% interest in the partnership when the simple math of the matter, as applied to the really undisputed method of calculating his interest, gets us at 14.16%. So that's how the trial court erred. Frankly, I think the trial court was confused by Mr. Bradford. I joked with my colleague, Mr. Huff, about having brought Mr. Bradford in to do a really good job of confusing everybody about the thing. So it's a question of law. It's not. It's a question of law to which math has to be applied. And when you do the math on it and apply it to the agreed methodology, then you get 14.16%. So,
sir, did you advance to the trial court your position as to a solid percentage of the ownership interest of the
we did.
And
Yes,
what
sir.
was that, what was that amount?
14.16%.
14.16. Thank you.
Thank you. I'd be happy to answer any other questions you have. My initial time is about concluded. So,
All right, Mr. Manus, we'll hear from you on rebuttal. And Mr. Huff, I'm sure you'll be glad to clear this up for Mr. Manus.
Can the court hear me now?
Yes, sir.
Okay. May it please the court, your honors, my name is David Huff. I represent Mr. Liles on this appeal. Obviously, we have a little bit different view of what the facts showed in this case. Let me give just a very brief recitation of the background. The court probably is aware of this, but of course, this partnership started in 2004, Downside Risk Professional Properties. Mr. Michael Young was essentially the money partner. He was going to provide capital in terms of raw land and money to construct buildings on that raw land. In exchange for that, he was getting 99% at that time of the partnership. Mr. Liles was a manager, or is going to be a manager of the properties, helping in both the construction as well as the management of those buildings once they were finished and tenants could be take occupancy in them. He was going by the agreement, the clear terms of the agreement, he could increase his percentage ownership in the partnership by percentages of service fees, as the court has seen in the pleadings and the memorandum. He was entitled to 2% of the net rents from Ivy Solutions, which was a business owned by Mr. Young. And I guess that was going to be kind of your anchor tenant. And then 7% of net rentals from other tenants in the buildings. And the proof, as Mr. Counsel has indicated, there's no dispute about the amount of those service fees over about 14 years that Mr. Liles performed services. The question is, what happened to those? Were they correctly accounted for, et cetera? Again, as counsel pointed out, there was this attachment A that was prepared by Bob Yates, Mr. Young's long-term accountant. The record shows we don't really know when it was prepared, although I found today, refound that in paragraph 9 of the answer to the amended complaint, Mr. Young asserts that that Mr. Yates prepared it after the agreement. So what we know is it was not part of the agreement. I would disagree with counsel in asserting that the parties agreed to the way that the service fees were going to be computed. What I will say was they accepted it, thinking that it was the right way. But what we found through this case is, in fact, no, it was not done the right way. Attachment A was not done the right way for a couple of reasons, and I pointed those out in the brief. Number one, it added an appreciation calculation, and the 5% was what was used by Mr. Yates. There's nothing in the agreement that provides for that. Number two, it failed to account for the Article 4 requirement, which required that the partners' capital accounts be adjusted each year by their respective share of profits and or losses. And that really goes to the crux of the partnership agreement, and that is Article 4 in regard to the issue at this point, which required that the net profits and losses for each fiscal year, and I'm paraphrasing, shall be allocated between the partners in accordance with their ownership interests for each year. And then when you go down to 4.03, it provided that that once a sale of property was made, that the distribution after expenses would be paid to the partners in accordance with their respective capital accounts, calculated after adjustment in accordance with section 4.01. In other words, this was something that was should have been a yearly ongoing thing, but it was not. Now, how do we get here today? As the court knows, in 2017, Mr. Young asked Mr. Liles to put up as collateral his interest in the partnership for an unrelated venture that Mr. Young had in Scottsdale, Arizona. Not surprisingly, Mr. Liles said, I'm not sure I really want to do that. It doesn't help me any. It just encumbers my interest. So he declined. Mr. Young didn't like it, decided he wanted to buy out Mr. Liles. and said, send me the attachment A, let's see what I owe. And he at that point found out, at least as to the calculations that had been made up to that point, based upon the methodology from Mr. Yates, it was 19.12. Mr. Young didn't like that. And as the record reflects, he contacted his accountant, Mr. Yates, and said, you need to look at this. Let's see what we can do. And as I pointed out in the brief and the record shows, Mr. Yates spent months, it looks like probably off and on, but months trying to re-engineer, and the words he used were reverse engineer the percentages. And obviously it came out in a way that was detrimental to one of his clients, Mr. Liles, but beneficial to his other client and longtime client, Mr. Yates. Importantly, we submit the proof is very clear that Exhibit 3, which was the initial attachment A, so to speak, that had been formulated through the years, and then Exhibit 5, which was Mr. Yates' redo of Exhibit 3, neither of those correctly states the partnership interest. And we submit also that the only evidence that correctly dealt with all requirements of the partnership agreement was Exhibit 14, prepared by Mr. Bradford. And pursuant to Article 3 of the agreement, it's clear Mr. Liles' service fees should have been credited to his capital account, and just like any other partnership expense, debited as an expense against the partnership. Admittedly, Mr. Yates admits this, that was never done. In other words, the K-1s were all wrong. The tax returns were all wrong. The capital account was wrong as well. And I've provided for the court on pages 15 and 16 of the brief, I hope this will be helpful to you, an example of 1 year showing how this was done incorrectly. That's on pages 15 and 16, and it encompasses tax year 2016. The bottom line of this is that at the end of 2017, Mr. Liles had an ownership interest. He had maxed out 20%. There is absolutely no doubt about it if the court looks at all the numbers. Now, Mr. Young would have this court conclude that, well, Mr. Liles was credited for his service fees because he received a percentage of the profits based upon at least what they thought were his or was his ownership interest. However, again, very clear, he did not have just a profits interest. He had a capital interest, a very different animal. The clear language of Article 4, which requires that his equity stake be calculated on an annual basis, requires an allocation of all income, expenses, etc., to each partner. So there's no doubt about that he had a capital interest, but he did not receive the benefits of that in the calculations as it pertains to his service interest or service fees. Because he had a 20% ownership interest in 2017, that also meant that he was and will be entitled to 20% of any gain, of any sale, of any partnership asset. And as the court knows, there was a sale of a building or two in 2018. It netted, I think, about 1.7 million. At the trial court level, Mr. Young, the court kind of in advance gave or allowed Mr. Young to take out, I think, 1.4 million, which was 80%. Mr. Liles was entitled or allowed to withdraw, I believe, 15%, leaving basically 5%. So there's $88,000 still at the trial court at this point in regard to that sale. But we submit that it's clear, and it is accurate, that if one has 20% ownership interest in the partnership, he is going to be entitled to 20% of any net proceeds on sale of any property at all. That leaves the final issue, and one that we do believe, Your Honors, that the trial court did not get correct, and that is the service fees. Again, as counsel has stated, there is no dispute about the amount of those. It's $118,175. The agreement specifically states, and I'll quote it again, all amounts allocated to David Liles to allow him to increase his equity stake shall be treated as income to David Liles individually and be an expense of the partnership for tax purposes. Neither of those was done, and that's confirmed by the K-1s, by the fact that Mr. Liles never received a 1099 in any year for service fees when he had service fees, and by Mr. Yates's own admission, the CPA. That's at transcript page 98 and 99. So how can that be fixed? Mr. Bradford provided an avenue for that. Really, the only avenue, I guess, that there is at this point, and that is DRPP, the partnership, needs to add that to Mr. Liles' capital account, send him a 1099, and set it as an expense against the partnership. Now, that does not constitute cash remuneration, despite counsel's contention to the contrary. It does not violate Article 3. In fact, a credit to Liles' capital account is required by Article 3. When there are service fees that he earned, it's required. So it does not violate Article 3 and should be ordered at this point. For all these reasons, I submit, Your Honor, that Mr. Liles, that the trial court judgment should be affirmed in all respects, except for that portion regarding the service fees, and that this court should order that DRPP credit his capital account for all those service fees, $118,175, so that he can gain the benefit as required by the agreement. Does the court have any other questions for me?
I'm hearing none from the panel. Thank you, Mr. Huff. Mr. Manus.
Thank you, Your Honor. I can say with absolute certainty that things are not cleared up in my mind. They may be in the mind of the court. I would point out a few things, though, I think that are important in connection with this agreement. This section 4.4 is part of Article 4, which is captioned Profits, Losses, and Distributive Shares of Tax Items. And Mr. Yates made that clear in his testimony that there's tax treatment and there's ownership treatment, and they're not the same thing. One involves profit and losses, and the other doesn't necessarily involve profits and losses. If at the end of the day, you've got an asset that's worth a lot of money, which may not be producing any income or any profits or losses, it still has a value that can be liquidated and distributed to the partners. And that's really what we're talking about here, is not, and of course, all that profit and loss stuff, as I pointed out earlier, is just simply not within the scope of the pleadings. We ought to be able, I believe, to rely on the pleadings as finalized 1 month before trial in this matter. Now, counsel has very artfully attempted to dodge the fact that this complaint both times asserts that the parties have followed attachment A right down to 2017 in calculating his client's ownership interest in this partnership. And that's been asserted under oath by Mr. Liles in the beginning, and again 1 month before trial in this matter. So I don't know how to get around that assertion on that. It is true that Mr. Yates came up with this attachment after the partnership agreement was signed, but in part, as I explained in my brief, that's because there is a missing term in this. Now, the courts are certainly entitled under our jurisprudence to include certain terms that are reasonable in this thing. And it would be unreasonable to assume, for the parties to have assumed, that this raw land worth $470,000 and the $5,000 cash would not appreciate any over the life of this thing once a big medical building got built out there. So Mr. Yates came up with 5%. That's actually advantageous to Mr. Liles, because based on that 5%, when you work it down, exhibits 3 that Mr. Liles came up with and exhibit 5 are identical, except for the additional capital contributions that everybody agrees my client made in this matter. So that brings us down to 14.16%. And when you do a simple cash cost of capital analysis, you get 14.86%. So Mr. Liles is sitting right on 14 to 15% either way in this matter. And so I guess my concern with all this stuff about the capital accounts and all that is that it's going to create more confusion than necessary, because the pleadings assert an issue of ownership percentage only and dissolution, which is agreed to in this matter. And so once we have established an ownership percentage, be it 14% or 20% of Mr. Liles, this court's work is done, and the trial court's work is done, and our work is done in this matter based on the pleadings as they currently are framed, or the issues are framed by the pleadings in this matter. So I'd be happy to try to answer any other questions. We're down to 1 minute in this matter. I've always enjoyed my appearances before this court, and I wish we could be back in the courtroom, but I understand why we can. So are there any questions that I could answer?
Hearing none, Mr. Manus, thank you. And Mr. Huff, I think you should be pleased that Mr. Manus, in the kindest fashion, has referred to you as an artful dodger in his argument today. So you can go home this evening and feel very complimented by that.
I won't worry too much.
All right. Thank you both for your arguments. We'll take this matter under advisement. Ms. Dempsey.
This honorable court is now adjourned.
Thank you. And counsel,